Further hearing in the appeal Whittington Hospital NHS Trust against XM.
Wow.
My lady, the bigger folder, I think, is a present from the appellants, which is, I think, the complete Law Commission report with MS numbers.
Right, and not necessarily to be opened before Christmas, but it is, in fact, the Law Commission consultation report. Because of the confusion about numbers, I thought it was the easiest if the court had it, the whole
It's
version.
actually too big for the ring binder.
Very sorry about that.
That's not your fault, it just happens to be that way.
It'll come electronically, Lord Forbes.
We have, in fact, already submitted it electronically.
Yes.
Oh,
There appeared to
frustrating.
be
Well done.
number issues, so that was an alternative.
Very long report.
And we also have McFarlane and
Thank you
Tayside,
very much.
yes.
Could I indicate that the intention over the next half an hour to 45 minutes is to address four key matters. First, shortly, is to deal with the gamete transfer issue by withdrawing a submission I made yesterday. Secondly, I'd like to look at the proportionality factors as defined within Patel, both because that is an important within Patel, but also because the court may see it of relevance in respect of any assessment undertaken under McFarlane. And so thirdly, I will then deal with McFarlane, and then fourthly, very briefly, deal with the Canadian case of Williamson. To deal then first with the gamete transfer point, and I apologise for not being able to answer my Lord Reid and Lady Hill's question yesterday about transfer. The answer, and it doesn't matter to our submissions now, but the answer to the question raised was if General Direction 6 does not apply, for example, because it's felt there's non-compliance with age, then within the Guidance Note 16 of the HFEA Code of Practice, revised in November 2019, paragraph 16.6, it asserts if compliance with all conditions in the relevant general directions cannot be assured, then an application to the HFEA for special directions may be made. And it's for that reason, and as I say, I apologise I didn't know that answer yesterday, that if I could invite your attention to our case, which is MS117, paragraph 6, and you'll see under paragraph 6 that we're there addressing the question of was the Court of Appeal's conclusion about the underlying purpose of the prohibition allegedly transgressed within the range of reasonable determinations. And we set out a series of factors under 6.2 and then all the way through onto MS 120, all of which we still rely on in support of the contention that there is not a purpose here to prohibit overseas Californian surrogacies. But could I invite you, I don't know whether this can be done electronically or not, we will not rely on the point that's taken when it says, also, this is on page MS120, above the time chart. It says also intended parents can have their gametes transported. Effectively, I'd ask that to be crossed out because we don't contend now that the approach of the HFEA, whether under General Direction 6 or under Special Directions, provides any assistance whatsoever in determining parliamentary intention here or in addressing the wider public policy issues.
So, which is the sentence that you want to cross out?
Also intended parents
All right,
can
okay.
have their gametes.
Okay, thank you.
And at the end, if the court wishes, I can I think we've got copies we could hand in of that guidance note with the relevant section and also what I find to be a very helpful flowchart.
Well, it would be helpful. Thank you.
Can I turn to the second point, which, as I've indicated, we see as a relevance to our case, which is the Patel illegality case, or our contention that the public policy case has to be considered under Patel, but also, and I'll return to this, provides factors that may be of interest under a McFarlane consideration. And so we are turning to the trio of necessary considerations again. And if I can invite the court's attention to MS 312 in Patel, and where we've reached is in paragraph 101, it's the last condition, C, keeping in mind the possibility of, and turning over to the next page, overkill unless the law is applied with a due sense of proportionality. And it's that I'm addressing. Within the judgment, Lord Toulson refers to a number of authorities which, in support of the contention that one should not have an absolute bar, but I think most usefully I can address the court's attention to his consideration of the Australian case of Nelson and Nelson, and invite you to consider within that, this is at MS 301, and to help the court later, the discussion on Nelson and Nelson starts on MS 299, and from that case, Lord Toulson quotes this at paragraph 53 from Mr. Justice McHugh in Australia, where he says, it is not in accordance with contemporaneous notions of justice that the penalty for breaching a law or frustrating its policy should be disproportionate to the seriousness of the breach. The seriousness of the illegality must be judged by reference to the statute whose terms or policy is contravened. It cannot be assessed in a vacuum. The statute must always be a reference point for determining the seriousness of the illegality. In dealing with the issue of the assessment of proportionality, Lord Toulson at paragraph 107 on MS 314 the 107, this is at C, he considered it disproportionate to refuse relief to which a claimant would otherwise be entitled. As a matter of public policy, various factors may be relevant. Professor Burrows' list, which I'll turn to in a second, is helpful, but I would not attempt to lay down a prescriptive or definitive list because of the infinite possible variety of cases. Potentially relevant factors include the seriousness of the conduct, secondly, its centrality to the contract, and thirdly, whether it was intentional, and fourthly, whether there was a marked disparity in the parties' respective culpability. And in respect of Professor Burrows' list, he refers to that earlier on MS 311, at paragraph 93. And this is Professor Burrows within a restatement of the law of contract. And what is said there, he notes a range of factors, and you will have at B, and really what I've highlighted for the purposes of this case is A, how seriously illegal or contrary to the public policy the conduct was. D, how serious a sanction the denial of enforcement is for the party seeking enforcement. E, whether denying enforcement will further the purpose of the rule which the conduct has infringed. F, whether denying enforcement will act as a deterrent to conduct that is illegal or contrary to public policy. And H, whether denying enforcement will avoid inconsistency in the law, thereby maintaining integrity of the legal system. From that, I would draw 7 points with reference to this case. The first point, A in Burrows' list, and the first item noted in Lord Toulson's suggestions, is how seriously illegal or contrary to public policy the conduct was. And I've already spoken about this yesterday, and I won't read this just so that you have the other context, at 109, Lord Toulson, MS 314, paragraph 109, and I won't read it out for the sake of time, but at 109 he notes that the courts must obviously abide by the terms of any statute. But I conclude that it's right for a court which is considering the application of the common law doctrine to have regard to the policy factors involved in the nature of the circumstances. So usually one is looking at examining a statute and determining if there's been a breach. But even if there has been a breach, the court will still often act in this context to protect the claimant and will deny the defence. In fact, the defence will rarely be allowed. And if I may just, for brevity, refer to the respondent's case at MS 116. And you will have seen the footnote there at footnote 24 on MS 116. And what we note there are a series of cases which are referred to within Patel, and we've included the Patel reference, in which the defence has not been allowed in respect of directly, frank illegal conduct, which includes insider dealing, fraud, drink driving, immigration offences, and since subsequently has entailed issues to do with fraud again. And to the point that, which I made yesterday, is looking at consistency in the law and seeing there a situation where those have been actually guilty of criminal conduct, nevertheless the defence has not been applied. And we would say that in this situation, there has been no breach of the statute or prospective breach of the statute by the claimant, by the respondent. In fact, even were she to enter into, which she's no intention of doing, even if she were to enter into a for-profit arrangement in the UK, that wouldn't be illegal either. The only illegality is based on what we contend is a hypothetical counterfactual, which is that somehow you have a third party entering into a for-profit agreement with her here. So there's no actual illegality. So then one turns to the question of public policy considerations. And in that context, we would note the notable shift in the legislative and wider social framework, but the legislative framework around surrogacy in this country, which now allows payments to third parties, albeit on a not-for-profit basis. And I hesitate because I don't know which bundle now to refer to, but I was going to refer to the Law Commission. This reference is actually is at MS 478, which may be the easiest place to find it. And this is 478, it's page 26 in the original commission, paragraph 2.15, where in the consultation report, they quote, two academics have recently suggested the distinction ought to be drawn between a truly altruistic model on the one hand and a compensation or paid model on the other hand. In light of their definition of expenses, they argue that the current UK law falls into the second of these two models. So rather than being purely altruistic, there is now a paid model. I'm not asserting that's the same as a for-profit model, but one can see that there's been a bright line change since the Bridie decision. Within the Bridie judgment, there's reference to commercial surrogacy. And at that time, that could have meant commercial in all its meanings. Commercial can mean buying and selling things. It can mean relating to businesses and their activities. And it can also mean making a profit. So it could have meant all of those things at the time of Bridie, whereas today, in this context, if you're talking about illegal commercial surrogacy in the UK, it's only businesses making a profit that's illegal. Businesses can be run, people can be employed, money can change hands, and on occasion significant sums can be paid to surrogates, provided that no one is making a profit. So at the time of Bridie, there was no need for a subdivision of the language of commercial, which there is today. And it's in those circumstances that the position in respect of California we would submit should not be seen as morally repugnant by those working within a paid model. As the Law Commission notes, and I don't need to put this up, is that others in the process here do get paid, lawyers get paid, and medical staff get paid, and it's felt that that doesn't corrupt the ethics of the process. And therefore, it can be said, and is said within the Law Commission, that there is not that great a distinction between the UK paid model and California. And for that, may I take you, and I think, again, hopefully this is within, I have it at MS 491, paragraph 6.36. And there's a discussion there about over international cases, and I'm reading from the sentence, the last sentence on the page. An international surrogacy arrangement through a reputable and well-established Californian surrogacy injury may present more similar features to a domestic surrogacy arrangement organized through a surrogacy organization than a Georgian or a Ukrainian surrogacy arrangement. So what we're saying is it's not that the UK is the same as California, and we discussed yesterday the pre-birth protections that are in place in the surrogacy model adopted in California. But what we are saying is that it is close to the UK, and the differences that are there do not form a sufficient basis for imposing the serious sanction of denying an otherwise recoverable loss. That leads me to our second point of the 7, which is tied to the first, which is we would say that the civil court here in denying a remedy would be imposing an additional sanction in circumstances where the criminal law would not impose any sanction. The third point is tied to Burroughs' list again, is how serious a sanction the denial of enforcement is for the party seeking enforcement. And tied to the submissions made yesterday, we would submit it is a serious sanction that runs the risk of depriving the respondent of the ability to found a family with her own genetic material or that of her partner, and further increases the risk of psychological injury to her. And the point I made yesterday was, given that she's lost so much that cannot be replaced, given the daily blight in her life from her bowel and bladder concerns, the problems with the intimacy with her partner, with her sexual dysfunction, none of that can be replaced. But the central loss here can be, and so therefore we would say it would be a very serious sanction. And she is in these unusual circumstances, and I stress this in the introduction, this is an unusual case. Because as a result of the defendant's negligence, and only as a result of the defendant's negligence, she is someone with a far more restricted scope to succeed in surrogacies than others. She has very precious remaining genetic material of her own that she reasonably, as found by the judge, wishes to entrust to a surrogate within the Californian system where there are pre-birth orders. And we would submit that therefore, in these circumstances, it would be disproportionate it would be an overkill to deny her remedy. I will deal with points 4 and 5 together, again, both derived from Burroughs' list. Whether denying enforcement will further the purpose of the rule which the conduct has infringed. And point 5, whether denying enforcement will act as a deterrent to conduct that is illegal or contrary to public policy. And this is a point that was in the Al-Grani article that was referred to by my learned friend. We would submit that it's hard to envisage any meaningful impact on the law in this country which bans for-profit surrogacy by permitting recovery of damages in this highly unusual circumstances of this case. We would say it would have no impact on the purpose of the rule, and there's no need for it as a deterrent. No one would seek state the obvious, no one would seek to be tortiously damaged. There are a very small number of claims. This is the first case that's come to the court since Bridie. And no one would choose to put them in themselves in this position where they're damaged and seeking to require damages. And no decision of the court here will, as I opened, impact on the statutory interpretation of the Surrogacy Arrangements Act. There will be no impact on the criminal sanctions there or the operation of it. It will have no impact on the operation of the grant or otherwise of parental orders within the family division. So we would submit nothing in your judgment will either deter or encourage intended parents to enter into overseas surrogacy arrangements. That's already happening, and there's no reason to consider that this would be a boost to it. The sixth point is whether denying enforcement will avoid inconsistency in the law, thereby maintaining the integrity of the legal system. On the one hand, as my Lord Reid was noting, there is the terms of the domestic law that is there, and we recognise that. But that is only the domestic law. And what we would say is, in looking in the real world at how the grant of parental orders occurs within the family division, it would actually promote consistency, because those who appear before the family division have to date all been granted parental orders in respect of overseas commercial surrogacies. And in fact, if you imagine a claimant who had the money to already undertake a commercial surrogacy in the USA, they would be presenting the Queen's Bench division with an already agreed parental order in the case. So that we would submit that therefore it would promote consistency within the working of the law. And we have a situation where, unlike within the family division, we have in this circumstances obviously Miss X indicating in advance what she's intending to do, and there's no indication that she's someone with any moral taint or attempt to defraud. The point 7, the last point, is derived from Lord Coulson's third comment, and that is whether there was a marked disparity in the parties' respective culpability. And that only points one way here. Looking at culpability, the only potential culpability rests with the defendant in relation to the initial negligence, whereas was noted and as set out within the facts, there was a litany of admitted failures at the defendant's hands on 5 occasions, and they also ignored Miss X's highly disturbing symptoms and dismissed her pain as psychological factors, which are set out within Appendix R3. So we would submit, therefore, in light of those 7 points, that the Court of Appeal here adopt a reasonable approach to proportionality, and that it was reasonable of them to conclude that it would be overkill to deny recovery, given that Miss X was not proposing to do anything unlawful or which warranted any form of sanction. Balancing the countervailing interests, the interests of ensuring full recovery, interest of respecting that she is looking to mitigate her loss, it would be disproportionate to deny recovery in this case. If I could turn then to McFarlane, which wasn't relied on by the appellant below, and we would submit that it was correct that they did not rely upon it. We submit that McFarlane is not applicable here in the context of what we say is an illegality or tainted by illegality defence, or what the appellant says is a public policy defence. You should have a copy of the judgment. One can see from the head note, if I may refer to the top numbers, I think there may be MS numbers as well, my lady. But page 59, this was a claim made by a married couple who, with 4 children, who decided they did not want any more children, and that the husband should undergo a vasectomy. There was an operation performed, and incorrect advice was given about the husband's sperm counts. As a result, contraceptive measures were no longer taken, and his wife became pregnant. And there was a normal pregnancy, and she gave birth to a healthy child. So what was an issue was whether it was permissible to impose a duty on the defendant in this situation to compensate for that the costs of bringing up that healthy child. And the House of Lords found that an award should not be made. And if I could just shortly invite consideration of the following passages. On page 89, within this, I think I have an MS number for that, 2009. At E, within the speech of Lord Hope, he describes, under child rearing case, that this is a claim for economic loss. The loss which falls to be considered on this head is the loss of rearing a normal, healthy child. And in respect of that, Lord Hope's ultimate determination can be seen at 95B. Where he notes that at B, I regard these costs as reasonably foreseeable by the wrongdoer, but in the field of economic loss, foreseeable is not the only criterion that must be satisfied. There must be a relationship of proximity between the negligence and the loss, which is said to have caused by it, and the attachment of liability for the harm must be fair, just, and reasonable. And he then goes on page 97 to conclude 97C, and this are considerations that are seen throughout the judgments, is effectively the impossibility of weighing up the benefits of having a child against the financial costs. It says, nevertheless, they're now bringing up the child out within their family. There are benefits in this arrangement as well as costs. So there's an equilibrium. In the short term, there's pleasure which the child gives in return for love and care which he receives during infancy. And then concludes, in my opinion, would not be fair, just, or reasonable in any assessment of the loss caused by the birth of the child to leave these benefits out of account. And at E, this is economic loss of account which must be held to fall outside the ambit of the duty of care. Lord Stein reaches a similar conclusion, but if I could invite your attention to one passage at 83D. And this was his basis for the decision. In my view, it is legitimate in the present case to take into account considerations of distributive justice. That does not mean that I would decide the case on the grounds of public policy. On the contrary, I would avoid those quicksands. Relying on the principles of distributive justice, I am persuaded that our tort law does not permit parents of a healthy unwanted child to claim the cost of bringing up the child from a health authority or doctor. If it were necessary to do so, I would say that the claim does not satisfy the requirement of being fair, just, and reasonable. Within Lord Slin's speech at 75H, he notes, again, his characterization is of this as an economic loss, and notes at the bottom of that page on to page 76 the applicability of Caparo and Dickman. And at C reaches the conclusion that it wouldn't be fair, just, and reasonable to impose the duty. And at D says this conclusion is not the result, as it is in some of the American cases, of the application of public policy to a rule which would otherwise produce a different conclusion. It comes from the inherent limitation of the liability relied on. And then finally on this, there is within the speech of Lord Millett at 108B, where he addresses the admission of a novel head of damage is not solely a question of principle. Limitations in the scope of legal liability arise from legal policy, which is to say are more or less inadequately expressed ideas of what justice demands. This is the case where the question concerns the admission of a new head of damage or the admission of duty of care in a new situation. Legal policy in this sense is not the same as public policy, even though moral considerations may play a part in both. Courts engaged in a search for justice, and this demands that the dispute be resolved in a way which is fair and reasonable in accord with ordinary notice of what is fit and proper. So from those passages, we make this submission firstly, that we would submit that as the appellant here relies on public policy based on the legality or illegality within the Surrogacy Arrangements Act, we submit that the McFarlane principles do not apply here. This isn't an economic loss to which the claim to which the policy restrictions outlined by McFarlane would apply, and hence is not a case in which one is looking at the need for consideration of the fair, just and reasonable condition. So our first submission is therefore that this is not a case in which legal policy applies. Our second submission, if you're against us on that, and contend that consideration should be given to creating legal policy in the context of a personal injury award for damages, would be to preennate the points that we have just made in support of the proportionality argument. And we would submit they do not support here the contention that principles of distributive justice require an absolute bar here. And what I noted in judgment, there was an equilibrium in McFarlane.
Did they actually use the word equilibrium?
I think I may be.
I think you may be picking up on a word that I used that was then expressly disavowed in the House of Lords in
Rees.
later in Rees. So I suspect you shouldn't talk about equilibrium.
Shall I say about
I thought that's
let's restore equilibrium.
yes, I thought that's what they were doing. But of course, I also thought that it wasn't really pure economic loss,
Yes, my lady.
because basically it was it was consequential on a personal injury. For one thing, and for another thing, looking after a child is looking after a child. It's not an economic loss, it's a different sort of loss. But that was just my view. But it had some purchase in the Rees case.
The point I would make here, what is of importance, whether one calls it equilibrium, whether one calls it balance, what was happening within the McFarlane situation was that they saw a situation where effectively the benefits of having a child matched the costs. And really the point we would make in this context is that that should not be applied here. There's no
analogy to be drawn,
Yes.
you are saying.
Yes, Miss X, if you find for the
I mean, to the contrary,
appellant,
your
yes,
submission is that the reverse is the case.
correct.
Yeah.
That's the submission. Could I then, in the hope of achieving my time scale, just very briefly turn to the case of Williamson, which can be found within, sorry, I hope I'm reaching the right bundle.
Is it tab 15, MS 407?
I think it is, sorry.
It is.
Usual Lord Wilson is on the button.
Sorry, I'm smart. I apologise. Too many.
Well, he's not on the button now.
So this is a judgment of the Supreme Court of British Columbia, and the facts can be seen shortly on MS 409, where you can see that Ms. Williamson was the sole survivor of a horrendous high-speed head-on collision that killed 3 other people, including her boyfriend, and she ended up they said it was astonishing she survived the accident and was permanently and severely injured. If I could invite the court to turn to MS 448. And there was a claim here made in similar terms to that of Miss X within a similar context. At 366, there's a finding made that the best and safest way for Miss Williamson to have a biological child would be to use the service of a surrogate. And she claimed for the cost of a surrogate in the United States of America. And you can see the public policy defence raised by the defendant on 449, paragraph 371. The defendant says that a specific award for surrogacy fees is not available, as such award would be contrary to public policy. To support this argument, he points to Section 6 of the Assisted Human Reproduction Act, 2004, which makes it illegal to pay a woman to be a surrogate in Canada. This Justice Gentleman then at 374 indicates, I do not agree, noting the Canadian case of Palmer, the court concluded this award was sanctioned legal conduct. In this case, there is no such danger. Miss Williamson is not seeking surrogacy fees to pay a surrogate in Canada, which would contravene the Assisted Human Reproduction Act. Instead, she's seeking fees which would allow her to embark on the lawful activity of compensating an American surrogate. The Assisted Human Reproduction Act cannot apply outside Canada's borders. The expert testified he was aware of Canadians successfully hiring American surrogates with no known legal complications. I've been presented with no evidence or case law which convinces me that this practice contravenes Canadian law in any way. And based on that evidence, an award was made. Just cited an example in another Commonwealth jurisdiction where an award is made in the terms that we would suggest.
Presumably, Bridie can't have been cited to her.
See no reference to. I don't think it was cited.
It's not referred to anyway.
The remainder, I'm again looking at the time, the remainder of the submissions are canvassed within the written case. You will see that if the court finds against Miss X on the issue of Californian surrogacy arrangements, we've set out their arguments in respect of recovery for UK surrogacy arrangements. And in relation to that, we would submit that that requires a straightforward application of the Livingstone principle in a 21st century context. Surrogacy is no longer something of last resort. It is part of modern society and part of accepted assistive reproductive options. And it will ensure recovery for her central loss, that loss of her inability to find her own family. And that we would say that there's no public policy issue here and that reasonableness mandates recovery. On the issue of donor eggs, we accept that there is a difference between a donor egg surrogacy and a surrogacy using a woman's own eggs. But for the reasons I indicated in I think it was my introductory point, my second introductory point, we would say again within the context of modern society and its recognition of the use of surrogacy and the recognition of its use, the use of donor eggs to create the myriad of familial entities that we have in the United Kingdom, that it does represent a fulfillment of the Livingstone principle by providing her with a family and in respect of those children as close as genetically possible, i.e. using the sperm of her partner. And it's for those reasons that we would submit that there shouldn't be a difference of approach between donor egg surrogacy and own egg surrogacy, and that both should be permitted.
Do you want to say anything about adoption, or would you say that's completely different?
We would say that adoption is different, and that the reason we say that is because that with with the surrogacy situation, the intent of the parties before birth is to create a child, and to create a child for the intended parents. And that it is now seen in 2019 as an ancillary reproductive choice. The difference with adoption, and this is canvassed within the Law Commission's report, is that clearly the child already exists, and therefore there are different considerations in play in that context.
Well, that's true, but of course those considerations could cut either way.
I'm not... That's
This
right.
is part of the commodification argument. I'm not saying that I espouse it, I'm just saying part of the commodification argument is the suggestion that surrogacy and indeed other forms of assisted reproduction create a child who wouldn't otherwise be there. They're creating a child on demand for particular parents, whereas adoption is providing a family for a child who wouldn't otherwise have one.
I accept that there are many different ways that people look at this situation, and that it's why we suggest that the appropriate route for the court is to be tethered within the legislation, and not to roam free, or not to board the unruly horse, because it is very difficult to resolve some of these issues. But it is clear within the United Kingdom, whatever views others may take, and whatever some people within the United Kingdom take, and they're perfectly entitled to that view, there is an acceptance of surrogacy as assisted reproduction rather than as something akin to adoption. And that in every case, I stress, this is a personal reproductive choice of the woman, and there's no judgment that should be made one way or the other. There may be some women who would be aghast at surrogacy and prefer adoption, and I can see that. Those were my submissions, unless there's anything further.
Thank you very much indeed, Mr. Johnston. You've withstood the challenges very doubtily.
Miss Watson reminds me to do one last bit of homework. It was when a tunnel yesterday I probably shouldn't have dived into in respect of immigration, and I promised, I think it may have been Lord Wilson, it may have been Lord Reid, the references to, in the Law Commission, to explaining the routes a child can enter the UK. Those can be found, I'm giving an MS number, maybe heroically, 1874, paragraphs 16.15 and 16.16. And that seems to note 3 routes that you can come in as a British citizen, if you've got a British passport. You can come in as a holder of with a non-British passport with an entry clearance. And if you could come in as a non-British passport from a country like the US, where you don't require a visa. But that's the reference, 16.15 and 16. I'm grateful for Miss Watson reminding me of that.
Well, it goes on to explain that in practice, it's a third route that's actually popular, which is to come in as a visitor from the US, and then, in other words, neither is a citizen nor is a holder of a nor is somebody with entry clearance, but simply come in as a visitor, and then presumably at that stage you must presumably apply for the parental order.
Yes, I presume so.
To regularise the
yes
the position.
It wouldn't necessarily regularise it.
Thank you.
Miss Watson?
My lady, my lords, I'd like, if I may, to have another go at looking at the Appendix 2, which I now think I have the same MS numbers as the court has. This is, and the MS number is 165. It's part of the Schedule of Damages.
Do you have the internal number?
The internal number is page 15 and page 16.
Yeah.
yes. Perhaps I spoke too soon about...
You did speak too
numbers.
soon.
About
Certainly not
165,
165.
Oh, right. Well,
And 15 and 16 are the particulars of claim.
oh dear. Well, the amended appendix number I was given was at page 164 and 165. It's part of the schedule, which comes towards the end of the bundle before the defendant's counter
Headed
schedule.
future surrogacy costs 1 and 2, is it?
Yeah.
It's
That's
exactly
internal.
future surrogacy costs 1 and 2. I'm so sorry about this. I don't quite know what's
I
happening.
mean, that's the page number of the written version, but unfortunately the MS version, which is the one on the
165 is part of what I have to remind parties is Lord Justice McComb's judgment.
Yeah.
He's referred to as Macomb frequently, but in the part of the United Kingdom from which Mr. Johnson and I hail, his name is Macomb, and I understand that is his preference.
I've clearly been here too long.
Well,
Well,
stand corrected.
We're all a bit fussy about how our names are pronounced, and I'm suffering from that myself quite a bit. But I hope that the court now has the future surrogacy costs 1 and 2.
Thank you.
This is part of the schedule, which, as the court will know, is part of the process whereby the parties assemble their arguments for special damages responded to by a counter schedule, either ruled on or compromised. And here we see what the costs were, prospective costs were in relation to the US. And they're quite considerable, as we can see. They include legal fees of a quite substantial amount, agency costs, US surrogacy payment costs, and interesting US egg donor payment costs. Now, it appears that this sum proceeds on the basis that there will be donor eggs rather than own eggs. I think that may be, to be fair, a mistake, because it's always been the case for the respondent that she wishes, insofar as possible, to use her eggs, and the finding on the balance of probabilities was that she would be able to use 2 of her own eggs to have children, but not 4. But anyway, that is the schedule setting it out. And of course, if they were using donor eggs, there wouldn't be any problem under the export of gametes or other genetic material. It's only if there is actually the use of material that we get into the territory which an only friend was discussing yesterday. The future surrogacy costs in the UK are on the other side of the page, which are obviously of a more modest sort, and they are under the heading, for example, of permitted expenses to the surrogate mother. And we can see the difference in the amounts.
What do the references to solicitor and barrister legal fees, which are enormous, mean?
Well, they weren't in fact canvassed in any great detail, and the judge didn't make much in the way of findings in respect to that. He had evidence from Lewis Guyvert, a solicitor with particular experience in the area. And I know that during the course of the hearing yesterday, my Lord Wilson invited, at least for the sake of argument, my learned friend to proceed on the basis that there had been a finding in respect of Californian surrogacy arrangements. In fact, if one looks at the judgment, there isn't very much in terms of any finding by him in that regard. What, of course, he does proceed to do is just to not allow Californian surrogacy, because he felt he was bound by the decision in Brady, whatever his personal inclination might or might not have been. He simply rehearsed the fact that there was a claim. So our submission would be that there is no finding by the judge which can be relied upon in relation to Californian surrogacy. What, however, the Court of Appeal did in this regard, and we get this from MS 137, is simply to say that Californian surrogacy is, inverted commas, well established, and pointed out that there was no criticism of Californian surrogacy by the respondent hospital. To that extent, I accept what my Lord observed. But there wasn't, it's fair to say, any detailed analysis of these particular figures in the schedule or any particular analysis of how it would work or might work in detail. I think it's common ground that Californian surrogacy, commercial surrogacy, is well established. It might be the most well established anywhere in the world. But of course, that doesn't mean to say that it will always be satisfactory on every occasion in the future. And I did point out, not in any way denigrating the sincerity or the efficiency of any arrangement that might be entered into by this respondent, that there are difficulties even in California and that there can be unsatisfactory matters there. And of course, it's always difficult for a court to police prospectively what might happen, because of course, in all these cases, or almost all these cases, one is going to be looking at what arrangement might be entered into in the future, and with 4 children, perhaps some little way into the future, and one does not know precisely what situations would pertain at that time. As to immigration, that was raised yesterday, and in fact, Lewis Guibert did give some oral evidence about this, which we see, and then there is the passage in the Law Commission, which is page 32, internal, and it's 1654 to 1667. I think it's probably fair to say simply that it's quite a complicated picture, and indeed that's one of the aspects which the Law Commission is consulting on by asking those who have been facing these difficulties what difficulties they've encountered, presumably with a view perhaps to creating some better degree of certainty under immigration law. But at the moment, it is by no means straightforward. I think we can say that. So apart from all the other difficulties, there might be problems in that regard. I wanted to say a few words about public policy, which emerged generally during the argument yesterday. And indeed, my Lord Kerr, said that public policy seems to have changed sometimes in the view that the courts have taken, for example, on the position of duties of care owed by police forces over the years. I think was the example that my Lord gave. And it is true, as we conceded in our printed case in an oral argument, the public policy is not immutable. From time to time, it will change. And one thinks in terms, perhaps, it's a good example where barristers at one stage were immune from negligence on grounds of public policy. The public policy was then identified in a different place, and there was a change. This was judge-made law, where the judges felt able to identify a public policy, perhaps particularly well able to identify that public policy, having regard to their experience of the court procedure. Whereas in other areas, we respectfully suggest it may be less easy for the courts to locate a public policy. We would also say this about public policy generally, that one of the ingredients in the analysis as to whether there should be a duty of care in a novel case would generally, whatever the particular fashionable description was from the courts, involve a policy element, whether it was the old style of Anne's and London Borough of Merton or Caparo. Although I would submit that recent authority from this court suggests that the fair, just and reasonable element in Caparo should very rarely indeed come into the analysis, while rather one should look at decided cases rather than looking at any particular case and saying, is it fair, just and reasonable? So that if there is a clear duty, the issue in a particular case was whether there was a breach of the duty or whether it fell outside the established law. So that the courts, I would respectfully submit, are shying away from, as it were, looking anew as to whether it is fair, just and reasonable to impose a duty.
I just wonder whether examination of the question of whether the finding of liability on the basis that it's fair, just and reasonable is miles away from public policy considerations. I mean, if something could be said to be fair, just and reasonable, it's a slippery concept in itself, in the estimation of the court, would that not inform consideration of whether public policy either provided an imperative for a finding of liability or an imperative against it?
Well, I think if one reads Macfarlane, for example, there are a number of different ways that one can look at this thing, whether it is considered not truly economic loss, whether it satisfies or doesn't satisfy notions of distributive justice, whether or not it's fair, just and reasonable, or too remote, or the myriad of other ways in which
Considerations, yes.
decide that they will not countenance a particular head of damage. But our respectful submission is that this court needn't be troubled by any of those very difficult areas, because, of course, public policy, we say, is very plainly identified and located within the statute. And therefore, the difficulties the court has from time to time, quite rightly in identifying public policy, simply evaporate here. And the exercise performed, we say, by Mr. Justice Brooke in the Rance case, and indeed by Sir Robert Nelson in following Brooke, and indeed Bridie itself by the Court of Appeal, is plainly an example of public policy being identified and leading inevitably to a certain result. In Macfarlane, there is perhaps quite an interesting passage which my learned friend referred to in the speech of Lord Millett, where it's at page internal 108, at letter B, where he is saying this: the admission of a novel head of damages is not solely a question of principle. Limitations on the scope of legal liability arise from legal policy. What is to say are more or less inadequately expressed ideas of what justice demands. This is the case whether the question concerns the admission of a new head of damage or the admission of a duty of care in a new situation. So this echoes the submission I was attempting to make, which is one's looking at a new situation to decide whether legal policy leads to a certain result. And in a sense, this is a new situation. Yes, it's one which has been considered by the Court of Appeal in Bridie, although the argument is that times have moved on. But this court is looking at it anew, albeit with the guidance given by, or we would say more than guidance, but the clear indication given by statute. He makes the distinction between legal policy and public policy, and that is a distinction which is well known, although sometimes somewhat difficult to locate.
Would you like to explain it?
No.
I thought not.
But,
A very wise disavowal.
But in any event, it is a well-established distinction.
It's frequently mentioned,
It is,
but never explained.
yes. My Lord Wilson asked me yesterday about benchmarks in terms of assessing general damages for pain, suffering and loss of immunity. As the court may know, in conventional personal injury claims, there is a award for general damages for pain, suffering and loss of immunity by judicial college guidelines as at least a starting point, and then parties will cite particular decisions if they think that they are an indication to cover a specific point. And of course, sometimes there will be a combination of injuries which makes it more difficult to fit within a particular category. But just to help my Lord to know what the maximum for these sorts of awards are, we looked at them, and for tetraplegia and for very severe brain injury, the total is £379,100. So that's, as it were, the top of the awards you can obtain for pain, suffering and loss of immunity. They are conventional awards. They're not supposed to represent anything other than a sizable award that the court feels to reflect the gravity of the injury.
I think my question was intended to focus upon this extra sum that you conceded should be paid within that general award, were this appeal in toto to succeed.
I'm grateful, my Lord, and my answer yesterday is the answer that I would give again today.
I see.
Could you just remind us of what that was?
What I said was that...
I may or may not have made a note, but I'm not going to check.
What I said was that if we were to succeed in full, then clearly the award would have to increase. Because what happened in the Court of Appeal was, because prospectively the respondent was going to have 4 children as opposed to 2, there was a reduction in the loss of amenity claim. Now, it follows, of course, that if there is going to be, by surrogacy at least, a reduction below the sum awarded by Sir Robert Nelson, there would have to be an increase to reflect the fact that there is no award. I suggested that since there was an adjustment of £10,000, it's hopeful that the parties will be able to agree an addition, and my lord asked me to suggest a figure, and I said perhaps £20,000.
But am I right that if the Court of Appeal are right on the Californian surrogacy, you're not challenging the figures as such?
I want to say just a little more about why we submit, in response to what a learned friend has said, that there should be no award at all for the cost of surrogacy, and why it's unsuitable for a special damages award. We do submit that it is an intensely, and will be an intensely difficult task for a judge to make an appropriate award in these circumstances. Not intellectually difficult, not suggesting in any way that it's beyond the scope of a judge's ability, but simply a task that we respectfully submit we should not ask a judge to perform. This is not like other medical treatments. It's not like the IVF case, which was referred to in Brady as releasing a blockage. This was a medical procedure done to a particular woman who had problems caused by a tort. It's not like adoption. I don't think it's suggested for a moment that the costs involved in adopting, which may often involve foreign travel, would be recoverable. But adoption concerns, and this was a point touched on by my lady a short while ago, is rather different. Here we're talking about a prospective child or prospective children. It involves an arrangement or arrangements with a considerable number of different moving parts, as it were. A glance at the schedule shows how many people might be involved, whether it is UK or US. Of course, there are intending parents or parent. There are intermediaries, perhaps quite a number of them. There is a surrogate mother who may well give of some of her genetic material in the process of gestation. And there is, of course, the child. This is a calculation of a wholly different order from any special damages calculation that we're aware of in any other context in personal injuries, so that it is breaking very fundamental new ground. It does not mean that one does not have intense sympathy for the respondent deprived of her fertility who wishes to go this route, but the question is whether or not it is appropriate for the court to order an award of special damages in those circumstances. Even in the United Kingdom, one can be certain as to whether surrogacy will be straightforward or even possible.
So, sorry, what principle are you saying we should apply in deciding that this type of claim goes too far?
A step too far was the expression used by my lady tentatively and obiter in the course of the judgment in Brady, whether it is too remote or simply an exercise that the court should not undertake, or not reasonable in the very special way that reasonableness is used in this context, or simply an award that this court does not think it is satisfactory that a court should award. There are examples where courts have decided whether there is illegality. Certainly this does not involve illegality per se, but it involves so many parts that the court, we submit, has to draw a line.
I mean, can you get, my difficulty is I don't have the sort of experience you do of what is practical, but I'm certainly conscious that there are cases which involve enormously difficult questions of fact about future possibilities, which are treated as relatively routine. What is the sort of distinguishing principle which you're asking to supply here, other than the sort of gut feeling that it probably goes too far?
Well, I hope I can elevate it a little above the visceral, but nonetheless, there are simply areas where one comes to the conclusion, for all the reasons that I have given and propose to elaborate on very shortly, that this is simply a bridge which should not be crossed. Let us put ourselves in the position of the hypothetical judge having to deal with a case of this sort, and indeed a defence counsel having to challenge this. Not a pleasant task for anybody to have to do. But a judge would have to consider whether or not somebody really wanted a child, really wanted as many as 2 or 3 or 4 children. Will they
This is the
persist?
stuff of judgment, is it not? This is what a judge has to confront, if not on a daily basis, certainly on a regular basis, to make a decision on the basis of the evidence that she or he has had and to reach a conclusion.
Yes, I'm not saying that it's as it were a different type of judicial process, but there nevertheless comes a time where, I gave the example yesterday, where Parliament intervened and said it isn't for judges to decide on somebody's prospects of remarrying.
Yeah, right.
Of course, judges could and did do that, using the sort of knowledge and experience that they would use when looking at any particular factual scenario. Judges do have to come to a view on expectation of life, and they marry up what different experts say about life. They do have to decide whether it is reasonable to seek medical expenditure for a particular procedure or not. But this is of a different sort because of all the different parties and because of the nature of it, the commodification of it, for want of a better word. The intense difficulty of having to decide whether it's realistic for somebody to want so many children, whether it's likely they will be able to find surrogate mothers, which is not easy to do, because as we know, it is a system which is, and that's one of the reasons the respondent says she favours California, which doesn't always result in a success. It is not, to use the words of one judge, a primrose path. It's a journey fraught with difficulty. You are not ordering.
Well, are you suggesting that judges should be relieved of this difficult task because it's just outside the area of expertise?
The fact that it's outside their area of expertise should not of itself be, of course, a reason, because judges will often have to decide difficult cases involving neurosurgical experts or neuroradiologists, which may not be within their expertise, but they have to do their best. Now, because of the fact that it involves fundamental questions of life, death, in personal autonomy, and so many uncertainties, and we can see that there is a wide variety of different views about surrogacy in general, let alone commercial surrogacy, so that this is an area where we respectfully submit judges ought not to tread at all. I indicated to the court that there were schedules which are customarily used in these cases. It's, of course, realistic to expect that after this decision, if the court upholds it, if there is a case of infertility, a claimant will include the costs of surrogacy as part of that schedule, so that the issue will exist. This may seem a floodgates argument, but it's a realistic argument. That is what will follow, and courts will have to decide, or parties will agree on the basis of there is a risk that a court might decide. It will become a feature of these claims. I don't want to suggest that infertility is an everyday occurrence, but it is not infrequent that a party will allege that as a result of some procedure, some advice, they have become infertile or less fertile, and therefore they seek damages. So it will become part of the landscape of this type of litigation. And that is why we submit that the court ought to be very wary before deciding that this is an area where the courts should go. My Lords, as to the Californian and the commercial surrogacy, I think I have probably said all I need to say about that. Our essential submission is that Patel and Mertzer is a very different case. I noticed that my learned friend didn't return to the case that apparently compelled the Court of Appeal so much, that Saxby and Fulton. He didn't deal with any of the other cases which do not seem to be consistent with it. And in our submission, the idea that it is perfectly reasonable to award damages because it is not unlawful to go to California, but the damages are in relation to an agreement which is specifically outlawed in this country, is not acceptable because, of course, we do not legislate for civil law in relation to other countries, whether it's California or elsewhere. The only limited extent to which we do so extraterritorially is usually in criminal offences like treason or murder or something of that sort. So our submission is that the Patel and Mertzer, valuable though it is essentially about the public policy of, does public policy really demand that this debt should not be paid back? That's a very different case to what we are dealing with, which is, should prospectively a court award damages to a claimant who has been rendered infertile once the costs of surrogacy abroad, or as of course we also say in the United Kingdom. And we say that with great respect the Court of Appeal were wrong to find that Patel and Mertzer cast some new light on the analysis which had been performed by the Court of Appeal in Brady. We say that the changes that have taken place in society and in terms of legislative interventions since Brady have not directly borne upon the central issue here. What they have done is changed and expanded perhaps our notions and understanding of what constitutes a family, but not more in terms of the attitudes to surrogacy.
Can I just ask you, Lord Fawkes, the argument against the recovery of the costs of a Californian surrogacy essentially is based on the policy expressed by Parliament in the legislation.
Yes.
I wonder if really the same argument might not be relied on to the opposite effect in relation to the domestic surrogacy arrangements which Parliament has legalised. What's going through my mind is this: at the time of Bryody, the claim there failed in part because the prospects of success were so slim that it wasn't a reasonable measure to take. My lady dealt in the section of her judgment headed intermediate cases with a situation where the prospects of success would be such that it would be a reasonable thing to do, to carry out to undertake a surrogacy procedure, and left open the question whether or not the cost of doing so should be recoverable as damages. And the main argument, well, the only argument I think mentioned by leadership against admitting that was that although the child would be a product of the claimant's own egg, fertilized by her partner's own sperm, and therefore genetically it's the same as she would have had otherwise, but for the accident, it wasn't going to be the product of her own womb. I was wondering what the strength of that objection viewed today really is. Insofar as there's a policy issue here, Parliament has provided that surrogacy arrangements of this kind are to be available lawfully for people who are infertile. I mean, that's the whole point, obviously, of legislation, to address problems of infertility. And if you have a woman who's been rendered infertile through a tort, why if the prospects of success are good, why, as a matter of whether you call it policy or fairness, justice and reasonableness, why shouldn't it be a recoverable head of damage?
Of course, the first point my Lord mentioned was the reasonableness. And we accept that in general terms it is not unreasonable for a claimant to go and seek a surrogate. We don't deny that. Of course, reasonableness has a very special meaning in terms of the law of tort. The basis of the decision then in Brady, some 20 years ago, the word used, I think, was not truly restorative. And that, I think, is the point that my Lord is indicating, that perhaps may not have quite so much force nowadays.
Yeah.
We respect...
you may not, obviously you're not getting, the woman isn't having the experience of pregnancy and childbirth. But I mean, if you think about general principles of damages, you're trying to put the claimant as nearly as possible into the position she would have otherwise been.
We respectfully see the force of your Lordship's observation, which was why the court may recall that when I was making our submissions in opening, I said that whilst we did not accept that public policy had changed since Brady to indicate a change as regards commercial, we had more sympathy for the argument that there had been certain changes which made the force of the distinction between donor eggs and own eggs less forcible. So in other words, I accept what your Lordship says, and I think that is consistent with our suggestion that public policy is not immutable, and that there have been changes, and we acknowledge those changes. And indeed, as I said, Lady Justice King expressed herself forcefully as regards that point, and the Court of Appeal didn't like the distinction any longer between donor eggs and own eggs, although I entirely accept what my lady said, which is that some people, perhaps particularly men, are extraordinarily concerned about the extent to which their own genetic material may be involved in the creation of a surrogate.
I think I may have some evidence for that, but I can't currently remember what it is.
Well, I'm certainly not... That may well be right anyway. And I'm sure it varies from individual. But
and from time to time, I suppose.
And from time to time. But my Lord said Parliament has allowed surrogacy. Of course, Parliament was faced with the problem that surrogacy existed and became more possible following IVF. It existed beforehand, but not to the same extent. So therefore, Parliament had to respond, or might have responded, by intervening in various ways to regularise some aspects of surrogacy. That's a better way of putting it. And that isn't quite the same, we respectfully submit. Regularising what is actually happening and saying Parliament is encouraging you to go down this particular route. That is a considerable step. So that they did not go that far, and from time to time there have been various minor interventions further to regularise the situation. So quite a few so-called civilised countries, to borrow the word, haven't legislated at all. They simply ignored it. Some of them make it unlawful of any sort of surrogacy, some stop at commercial surrogacy. There's a huge variety of responses. But what we submit is the fact that Parliament has intervened could not be taken to say, well, Parliament is saying that UK surrogacy is fine, therefore there is no reason why you should obtain damages for personal injuries. We say that is a considerable jump and not one the court should make. I was saying that I did not think that my friend was very wise not, in fact, to rely on Saxby and Fulton and other cases. He did, however, focus very much on Patel, and in particular suggested that denying a remedy would result in overkill, to use the words which we get from Patel. And he said there was no prospect of the respondent doing anything unlawful. Well, it's true that she would not commit a criminal offence because of the specific exemption provided for by the Surrogacy Arrangements Act 1985. But inevitably, she would be involved in an arrangement which is unlawful. And therefore, her own position might be that, understandably, she would not be prosecuted. But to say there is no illegality involved is not, we respectfully submit, correct.
I'm sorry, what is unlawful?
Well, it is unlawful to enter into a commercial surrogacy arrangement. The 1985 Act, which perhaps I can take a lordship.
No,
to.
I'm just, what's she doing? If she has to do something in this country, as I understand it, a surrogacy arrangement in the Act includes a Californian surrogacy arrangement. But the crime is to do something in this country by way of negotiation of such a thing.
So that she would commit a criminal offence, except for the exemption. Anybody involved, but she and the surrogate mother would not be prosecuted, but otherwise, and there's a specific exemption in the Act. But anyone else involved in a commercial surrogacy arrangement, even the family solicitor, commits a criminal offence, whether or not, they certainly wouldn't be prosecuted, but they would commit a criminal offence, whether or not the surrogacy arrangement was in California or in the United Kingdom. Of course, if a Californian attorney entered into agreement, then that different considerations would apply. But the transaction, a commercial transaction, is scored through.
That's assuming she sends an email or something from this country to a Californian agency, does it?
Yes, that might be stretching it a little, but I mean...
I'm just wondering what it is she's doing in this country, which, apart from the exemption, would be the crime.
Well, there are interesting arguments as to how far you have to go in that particular passage I referred to yesterday, but there is a suggestion that you have to be particularly wary not to do anything which could fall foul of those provisions.
But if she did the whole thing from start to finish while she was in California,
I think
there would be no criminal.
I think that would be correct, yes.
Yes?
Presumably, the fees being charged by solicitors and barristers would suggest there is work being done in this country as well.
Well, enormous fees
Yes, enormous fees.
Enormous fees.
being charged by solicitors and barristers, which I don't think they have in California. That's why I asked
No,
the
well,
question.
there's a separate figure for US legal costs, which is a
Yes.
fraction of
New
the
York, but not
British
in
ones.
California, actually. Anyway, there wasn't much examination of that. So that our submission is that it is not a question of overkill. And of course, it is an irony about the position, which is that the Learned Friend's written case acknowledges that supposing, hypothetically, she entered into a UK commercial surrogacy arrangement, I think it's conceded that she wouldn't be able to recover the costs of that, even if it was cheaper than California. It is only because he argues that you escape the net of the Surrogacy Arrangements Act 1985 that you can, as it were, argue that this is another matter, it's a matter for California, and therefore a recovery is possible. That's an unusual result, we submit, of the submission that he makes. So he indicated that this was a very much a one-off case. It was the first case, he said, since Brady. Well, to that we say it won't inevitably be the last case. We also return to a submission that we made briefly yesterday, which is that there is one factor that we can get out of Patel, which is the need for integrity within the legal system, and to be able to recover damages in tort in relation to a transaction which is unlawful by an Act of Parliament which provides for criminal sanctions does, in our submission, compromise the integrity of the two systems. In Wilhelmsen, there was, as my Lord Reid pointed out, no reference to Brady, and Sir Robert Nelson suggested that that decision would not be followed in this country, but there it is. It's a decision which the Lordship's attention has been drawn to. So Unless I can assist any further, those are my submissions in reply.
No, it appears not. Thank you very much indeed.
However,
Thank you.
before the court rises, I would, if I may, like to say something. My lady, everyone in this court is aware that this is your ladyship's last case as President of the Supreme Court. And I know that shortly there is to be a proper valedictory to you, but I hope you will forgive me if I say a very few words on behalf of all those involved in this case. While I do not speak officially on behalf of lawyers like me who've had the privilege of appearing before you over the years, I hope and trust that they would agree with what I want to say. Appearing before your ladyship is always a taxing experience. A hearing is conducted with intellectual rigour, but it is always collaborative in the sense that the clear impression that one gets is that the court is seeking advocates' assistance in coming to the right conclusion in a particular case. As president of this court, your reputation has grown enormously, as of course has that of the court. Your judgment will be studied for years. Some of them may even be followed. And your sense of style has gathered you a fan base well beyond the normal cohort of court users. I know, my lady, there is more judging in other jurisdictions to come, and no doubt many lectures, learned articles, and contributions to debates in the House of Lords. But may I have the honour and privilege, on behalf of all of us, in wishing you the very best for the future and expressing our gratitude to you for the immense contribution you have made to the law.
Oh, Lord Fawkes. That's overwhelming, completely unexpected, and completely upstaging whatever is going to happen tomorrow.
Even better.
When I plan to respond with some of the choicer insults which have been directed my way as well. Thank you so much, much appreciated, and it's always a pleasure to have you appear in front of us, both of you. Thank you. And having said that, we're now going to go away and work out. This is a very difficult case. It's a very sensitive case. We know that. And we shall do our best to produce an answer as soon as we can.